2. The common law. The term common law is used to describe many things. A rule, a principle, a group of rules, a body of principles of justice and fairness, a type of legal system, a method, a process, and a tradition. However the term is used, courts constitute a focal point in the common law method, process, and tradition. Some people therefore conclude that common law refers simply to rules made by courts or judge-made law. But this understanding of the term is too narrow. As Roscoe Pound explained, the common law is better understood as a mode of judicial and juristic thinking, a mode of treating legal problems rather than a fixed body of definite rules. Pound realized that the term common law not only describes the legal rules made by courts, but also encompasses the processes and principles by which courts make legal rules. In Pound's words, the common law consists of the body of authoritative materials of judicial determination, the body of received materials in which those who decide cases are held and hold themselves bound to find the grounds of decision, and the process of determining controversies in accordance, so far as may be, with the authoritative materials for decision. According to Pound, when speaking of the common law as a legal system, we must have a grasp of the authoritative materials of judicial determination, which I will here call legal sources, and of the judicial process of determining controversies in accordance with legal sources. These two central aspects of the common law legal sources and judicial process underlie the structure of my common law arguments. I argue that common law judges have two cardinal obligations: to apply the law and to develop the law. When discussing each of these obligations, I advance two parallel but independent arguments resting on legal sources and the judicial function within the common law adjudicative process. In other words, I argue that the judicial obligation to apply the law and the judicial obligation to develop the law can be derived from Anglo-American legal sources and from the common law judicial function. A. Sources. Pound's view of legal sources is familiar to any lawyer in a common law regime. Sources are distinctively legal because they are recognized as authoritative within the profession. These are the materials to which lawyers turn in researching questions for clients and presenting arguments to judges, and on which judges rely in drafting the opinions that support their rulings. Pound shares his notion of legal sources with, among others, John Chipman Gray. This traditional view of legal sources is closely related to the sources thesis advanced by Joseph Raz. Sources, as viewed by Gray and Raz, are, as Raz says, clearly related. Gray and Raz disagree, however, about the status of moral norms as legal sources. Gray believed that moral principles are or can be legal sources. It is not clear, however, whether Gray should be seen as a traditional natural lawyer or an inclusive legal positivist. In other words, it is unclear whether Gray viewed the association of moral principles and legal sources as necessary or contingent. Whichever Gray would have preferred, Raz disagrees. For Raz's exclusive positivism, moral principles are never legal sources, although they may sometimes inform judicial reasoning. Pound does not align himself with Gray or Raz concerning the identification or connection of law and morality as necessary, contingent, or non-existent. I will follow Pound's lead. Pound, Gray, and Raz, together with John Finney's, all agree that there are certain materials recognized as authoritative legal sources. As I will use the term in the next few pages and throughout this book, this is all I, too, mean by legal sources. I am interested in a fact about legal reasoning. According to the traditional view, to which I subscribe, legal reasoning proceeds from and relies on a limited domain of recognized, authoritative legal sources according to which lawyers and judges formulate and evaluate legal claims and arguments. Before discussing precisely which materials constitute legal sources, I should clarify some terminology. I conceive of a judicial system as consisting of three standard tiers: courts of first instance, intermediate appellate courts, and courts of last resort. I refer to courts of first instance as trial courts, to intermediate appellate courts simply as appellate courts, and to courts of last resort as high courts. When discussing the American legal system, I use the denomination high courts to refer, where appropriate, to the court of last resort in a state judicial system and to the U.S. Supreme Court. In the English context, High Court refers to the House of Lords. Legal sources include official or primary sources, such as a constitution, statutes, regulations, and case law. Official sources are not, however, the only legal sources in common law systems. Melvin Eisenberg supplements official sources by providing a comprehensive definition of common law legal sources. Courts reason from doctrines found in texts that are not formally binding on the deciding court, but are nevertheless generally recognized by the profession as authoritative legal sources. These texts include official sources, such as cases decided by courts outside the jurisdiction or by lower or parallel courts, and secondary sources authored by members or students of the profession, such as restatements, treatises, and law review articles. By differentiating between official sources and secondary sources, Eisenberg's definition heeds a traditional distinction of the common law. Secondary sources are recognized as legitimate resources to which judges and lawyers may turn in making legal arguments. But they are not law in se, unless and until asseverated in a recognized official legal source. In fact, there are two distinctions here. The first distinction is between official legal sources and secondary legal sources. The second distinction is between legal sources, official and secondary, and other, extralegal materials. At the risk of oversimplification, official sources constitute the law. Secondary legal sources contain legitimate bases for legal argument and reasoning. Extralegal sources may sometimes be relevant and referenced in a legal argument or decision, but they are not recognized as bases for legal argument. Eisenberg includes as legal sources texts that are not formally binding on the deciding court. One category of non-binding official sources mentioned by Eisenberg is decisions of lower or parallel courts. From the appellate court perspective, decisions of lower courts are decisions of trial courts. Eisenberg therefore includes trial court decisions as legal sources. This seems sensible and accurate. Trial courts have perhaps the greatest influence over what the law will become, because trial courts usually have the first say, even if not the last, about what the law is. Of course, trial courts are sometimes overruled by appellate courts, but trial court rulings are far more frequently affirmed. Furthermore, even where a trial court is initially overruled, high courts frequently overrule intermediate appellate decisions by adopting the rationale originally expressed by the lower court. In addition to the specific examples Eisenberg offers of non-binding official sources, I would add dicta and dissenting opinions. I include dicta as legal sources because very often what begin as dicta later become the source of important judicial decisions. The considered language of the U.S. Supreme Court should generally be treated as an authoritative legal source, whether contained in the holding or in dicta. To take a famous example from American law, Chief Justice Harlan Fiske Stone's footnote in the Caroline Products case became a wellspring for later awareness of the constitutional import of the distinction between economic and personal rights. Stone's statement also guided courts in appreciating the distinct importance of personal rights and the court's role in preserving and protecting these rights for American citizens. I include dissenting opinions as a source of law for similar reasons. Yesterday's dissenting opinions have often become today's law. In fact, some of the most famous opinions of some of the most venerated figures in American law were written as dissenting opinions that ultimately shaped what the law would later become. Some of the most significant decisions from which the Justices Brandeis and Holmes dissented had been reached by a bare majority of the court, and increasingly their dissents came to be shared by one or two other justices. Surely the dissenting opinions of two such powerful intellects as Holmes and Brandeis may be assumed to embody their most deeply felt precepts about the American constitutional system. What Felix Frankfurter wrote about Holmes is equally true of Brandeis. Some of his weightiest utterances are dissenting opinions, but they are dissents that record prophecy and shape history. As with dicta, it is not necessary for dissenting opinions to become accepted and incorporated into majority opinions before they transmute into legal sources. They are recognized as legal sources when they are written. Eisenberg's definition of legal sources is responsive to certain facts about common law systems, common law reasoning, and the common law process. Legal sources must be discerned from the perspective of the court reviewing information that it can rely on or refer to in resolving a legal dispute. Eisenberg labels this court the deciding court. A suitably expansive definition of common law legal sources must include the entire universe of legal authority on which a deciding court can rely in resolving a pending case. Deciding courts can and do refer to and rely on trial court decisions, dicta, and dissenting opinions. Indeed, one important reason that trial court opinions, dicta, and dissenting opinions are published in common law systems is precisely so that they may be used later by judges and lawyers in reasoning about a legal problem to resolve a legal dispute. The definition of legal sources that I use includes official sources understood to include trial court decisions, dissenting opinions, and dicta, and secondary sources. B. Process. Pound thought that to comprehend the common law system, one must understand legal sources and the judicial process. I have just discussed legal sources. Now I will turn to the judicial process. As a judicial process, the common law refers to litigants raising claims in lawsuits, providing a court with different arguments in support of or defense against these claims, and having their claims resolved by a judgment, which is typically supported by stated reasons for the judge's decision. As a type of legal system, the common law focuses on the court's role in fashioning rules as a result of the process of raising, reasoning about, and resolving legal claims. For Pound, two determinate concepts connect all common law systems. Along with the doctrine of judicial precedent, this doctrine of the supremacy of law is one of the distinctively characteristic institutions of the Anglo-American legal system. In fact, Pound considered the doctrines of precedent and supremacy of law to be the two fundamental doctrines of the common law. By supremacy of law, Pound refers to a doctrine according to which courts are positioned and empowered to review executive and legislative acts and, if necessary, to invalidate them as inconsistent with the fundamental principles of the common law. The legal source to which Pound traces the doctrine of supremacy of law is the famous statement of Edward Coke in Dr. Bonham's case. I will examine Lord Coke's opinion in Bonham in detail later. For now, it is sufficient simply to note that in Anglo-American legal history, Bonham was the first judicial pronouncement of the authority of common law courts to review legislative and executive acts to ensure compliance with common law principles. As Pound uses the phrase, supremacy of law refers to this power of judicial review. Pound's belief that the doctrines of precedent and supremacy of law are distinctive signifiers of common law systems should not be regarded as a crude essentialist position. Pound does not suggest that a legal system must possess the dual doctrines of precedent and supremacy of law to be a common law system. Nor could he. As a legal system, the common law predates the development of both doctrines. Pound is better understood as making a broad, descriptive claim that any vibrant, full-blooded common law system will possess these two doctrines. Pound noticed the historical fact that all modern common law systems possess some version of both doctrines. Pound also perceived that these doctrines best allow common law systems to balance the sometimes competing aims of stability, flexibility, and equity. Pound maintained that we must understand the common law judicial process to understand the common law legal system. Understanding the doctrines of precedent and supremacy of law is fundamental to understanding the internal process of common law adjudication, that is, the institutional principles and methods according to which judges decide particular cases. But a full appreciation of the common law judicial process also requires an understanding of the external process of common law adjudication. That is, it requires abstracting the process of formulating, following, reviewing, and revising legal rules in the context of resolving lawsuits, and viewing this process across the vista of different courts, times, and sources of a common law system. The external process of common law adjudication overlays the entire legal system. Frequently, we conceive of the common law as the legal rules articulated by courts in the course of deciding cases. And this is one meaning of the expression common law. But common law also describes a process of adjudication that applies not just to cases involving judge-made rules, but to all cases that arise for resolution by courts within common law systems. The common law adjudicative process applies to constitutional and statutory cases, as well as in the areas of law, more typically categorized today as common law. The dialectic method of common law, reasoning through the adjudicative process, contributes to the articulation, evaluation, and refinement of all areas of the law. We frequently differentiate bodies of law, constitutional, statutory, and common law, as distinct categories of official legal sources. But here we must be careful to distinguish between the common law, as describing a body of legal principles, and the common law as a method of reasoning and a process of adjudication. Considered in the latte sense, the common law method and process developmentally administer the realms of constitutional and statutory law, just as they do in, say, tort or contract law. Understood in the former sense, certain common law principles operate at a constitutional level, subjecting governmental action to the rule of law and curtailing abuses of legislative and executive power. Functionally and historically, the common law courts apply common law principles through the common law process to ensure that the rule of law governs the government and the individual in public and private spheres of law. The purported contrasts between constitutional and common law and between public and private law are neither sharp nor perspicuous in the common law. This is true, as I have said, as a matter of process and substance. The same method regulates the articulation and development of these areas of law, and the same principles and doctrines arise in each type of case. Retaining these somewhat artificial distinctions for the moment, constitutional law, as a body of law deemed to be subject to common law process and principle, is most relevant to the argument I will here pursue. As I explain more completely later, there was no historical splintering of constitutional law and common law. Even though we are accustomed today to differentiate between common law cases and constitutional cases, this is a mistake that impedes a proper evaluation of contemporary constitutional adjudication in common law jurisdictions. The common law tradition and process best describe and explain constitutional adjudication in modern common law systems, and common law principles of constitutional dimension operate in contemporary constitutional adjudication and decision-making of high courts and common law jurisdictions. See content. The previous discussion of common law reasoning with authoritative sources through the judicial process requires that I address a debate in legal theory about the relationship between the identification of the law and the moral evaluation of the law. The notion that the content of the law can be identified through a rule of recognition without recourse to moral evaluation is most often associated with exclusive legal positivism. Among modern theorists, Joseph Raz articulates and defends this view most prominently. Some contemporary inclusive positivists hold that the rule of recognition itself can, in particular jurisdictions, incorporate substantive moral criteria into the process of identifying what the law is. In other words, these positivists claim that what is identified as law in certain jurisdictions depends in part on its compliance with or expression of certain moral values. Ronald Dworkin rejects the rule of recognition entirely. Initially, Dworkin seemed motivated to reject the rule of recognition because he believed no rule of this type could identify the principles immanent in the law, which are sometimes cited and used by judges to resolve difficult cases. In later work, Dworkin argued that the law's content can never be fully determined in isolation from its moral evaluation. According to Dworkin, the law's meaning is constructed by judges during an interpretive process that involves at every stage the evaluation of legal sources in terms of political morality, with due consideration of social norms, constitutional values, historical facts, and institutional obligations. Dworkin sometimes writes about these stages and dimensions of interpretation, as though they are discrete and autonomous moments and modes of analysis. He makes it clear, however, that even at the pre-interpretive stage, when the tentative content of the materials to be interpreted is established, A form of interpretation takes place about which different interpreters will disagree concerning which materials are properly necessary for purposes of interpretation. Another way Dworkin describes this interpretive dynamic is that the content of law is determined at the doctrinal stage in accordance with the aspirational values of law and justifications of legal practice formulated at the jurisprudential stage and expressed through the decisions of judges at the adjudicative stage, which are based on claims made at the semantic stage. For Dworkin, morality is principally relevant to determining the content of the law at the doctrinal and adjudicative stages, when judges decide both what the law is and how to honor their responsibilities as judges. However he expresses it, Dworkin's idea here is that morality enters into the construction of the law's content through judicial interpretation of the moral values that underlie the law, the legal system, and legal practice in a given jurisdiction. According to Dworkin's account, the rule of recognition cannot help us judges and unjust laws identify the content of the law because of pervasive social disagreement about the meaning of language, history, morality, politics, justice, doctrine, and institutional responsibility. This is the core claim of Dworkin's semantic sting challenge to positivism. As deployed in judicial reasoning, these concepts are interpretive rather than criterial or natural kind concepts, because their meaning is determined not by a conventional understanding we all share or by a true essence they possess, but rather through the process of interpretation in light of the point or purpose of the practice being interpreted. Some scholars conclude that Dworkin must therefore deny either that there are identifiable legal sources or the importance of legal sources for legal reasoning. This is incorrect. Dworkin offers an alternative account of legal sources and legal reasoning. I must briefly clarify a common misconception about Dworkin's position. The fact that morality is used to determine the content of the law does not mean that the content of the law is whatever would be morally desirable for the content of the law to be. This point is crucial because no one, Dworkin included, could responsibly claim that existing legal materials, concepts, and doctrines do not at all constrain the reasoning and decision-making of judges in actual cases. Dworkin explicitly acknowledges the importance of institutional and doctrinal constraints on the invocation of moral principles through judicial interpretation. The fact that Dworkin rejects the sources thesis does not mean that he rejects the notion of legal sources or their relevance to legal reasoning. He believes instead that the content of these sources is determined through the process of interpretation, rather than through a rule of recognition, and that this interpretive process will ordinarily involve an assessment at each interpretive stage of the relevant legal data according to their substantive moral worth in light of the normative values and institutional constraints operative in that legal system and culture. For Dworkin, the substantive content of the law is not identified prior to adjudication and possibly changed as a result of the adjudicative process. The content of the law is determined through the interpretive process of adjudication. I am not here going to engage debates concerning whether positivism is or is not committed to or undermined by criterial semantics, or whether inclusive positivists are no longer truly positivists as a result of their acceptance of moral conditions for legal validity in certain jurisdictions. For the purposes of my argument, legal positivists of whatever stripe will view the expression of a judge's moral convictions in terms of a common law norm through the analytic framework of the sources thesis. My argument can be understood in this fashion, though Dworkin would view my argument somewhat differently. In Dworkinian terms, my argument would mean that judges determine the content of the law in terms of moral principles that are embedded in the common law and articulated through the process of judicial interpretation and decision-making. Dworkin would argue that certain apparent forms of legal injustice are actually not part of Anglo-American legal doctrine, when properly interpreted by judges in accordance with fundamental commitments to justice intrinsic to this legal tradition. My argument can be read this way as well. For purposes of applying Dworkin's theoretical approach to the argument of this book, the principle of legality, which I discuss in chapter, probably offers the best example of a fundamental common law principle whose content is determined through the interpretive process of adjudication. As I explain in detail in chapter, The content of the principle of legality as a constraint on government action can be understood to be determined through its interpretation and application by judges in accordance with their perception of the point of the unwritten English Constitution. English judges disagree about the relationship between common law constitutionalism and parliamentary sovereignty, and these disagreements filter into their respective views of the constraints the principle of legality poses for government action. In other words, the substantive content of the principle of legality, as it relates to the recognition and enforcement of specific legal rights against the government, is determined by the rationales offered by judges reviewing alleged infringements of fundamental rights by the government. For Dworkin, what the principle of legality means what the content of the law is can only be determined by carefully considering the arguments offered by judges to explain the rights that English citizens may possess in a particular case, not by attempting to fix at a moment in time what existing legal sources say about the principle's meaning. Some, possibly most English judges would not apply the principle of legality as vigorously as others in safeguarding individual rights, because of an expansive conception of parliamentary sovereignty that they believe is most fundamental to English constitutional values. Other judges believe that the principle of legality serves as a presumption of general application operative at a constitutional level to protect fundamental rights and to maintain fundamental constitutional commitments to the rule of law, at times by constraining government action. According to Dworkin, if the latter judicial interpretation of the principle of legality, regardless of whether it is the majority view, is the interpretation that coheres with English legal doctrine and constitutional commitments, and also provides the best expression of English law in terms of substantive justice, then this is the meaning of the principle of legality. Considerations of justice cannot be dissociated from the articulation of the doctrinal content of the principle. D. Structure. In this chapter, I have focused on two facets of the common law's structure: the recognition of certain distinctive legal sources and the centrality of the judicial process for any adequate appreciation of a common law legal system. As I discussed earlier, I will develop, in this book, two interrelated but independent lines of argument tied to each of these facets. The first derives from and depends on Anglo-American legal sources and is therefore tailored to particular common law systems. The second stems from the judicial process and common law judges' defined role within that process, and applies generally to any properly designated common law system. The two most fundamental common law principles, according to Pound, are the doctrines of precedent and supremacy of law. Grounded in their legal sources, these two fundamental principles are the basis for my arguments about the basic judicial obligations in common law systems. The doctrines of stare decisis and legislative supremacy inform the judicial obligation to apply the law. The doctrine of supremacy of law, which I will call common law review later in this study, is the principle that engenders the judicial obligation to develop the law. Analyzing legal sources and judicial function, I will examine each of these obligations in depth so that we can better apprehend the judicial process and the ways that this process forms the indispensable cynosure of the legal systems we describe with the term common law.